Thank you, Alexander. And before we move to opening up the floor to questions and at the discussion, I think that Mr. Hustinx, as this debate is heavily regulated, of course, Mr. Hustinx an opening speech was shorter, and of course he deserves the right to comment on what has been said after his speech, because I think many of the comments were also addressed to him. So, Peter.
It's not a matter of needing more time. I can be brief in the second round as well. There's an awful lot of subjects, and I have to choose. But let me first say, in search of global standards. Basically, these standards already exist. That's the message. There is a great overlap. We would need more time to have a UN approved, but that's not the main thing. I think it already is there. And the big players have understood. The big corporates are investing in simple solutions which apply across the globe. And then in 63 countries which do not have data protection legislation yet, that's a small number relatively, they simply cover by a uniform approach. It's called binding corporate rules. There are other solutions, and that's an approach which makes sense. So that's my point one. As we go, we need to revisit the existing legal framework. I made some general comments along this line also, and I agree with Peter Fleischer when he says that the mechanism of adequacy findings is probably too cumbersome. Okay, this is what we have now. We can do better. We need to make sure that we build in more global privacy. We have to, in these European frameworks as well. Probably also the criteria for applicable law. If there is something to protect, there is a real European interest, I think that would be an interesting attachment. But that's future, and it does not block good approaches which are enlightened. Then you made an interesting point again, Peter, when you discussed the possibility that Street View in Canada could be different from the US. That's interesting. That is an example of ICT architecture on the net which would distinguish on jurisdiction. He did not make that point in the discussion of retention, but I think we should want to see more of that differentiation and different functionalities, which is responsive to culture and legal environment. On retention and time limits, let me use this occasion to I've not discussed the data retention directive, I've referred to other directives, but that data retention directive does not apply to content like searching behavior on the net. So it may apply, yes it does apply, to some traffic data in email, but in terms of internet browsing behavior, it is minimal indeed. So let's not be confused about this. If Google is thinking about a search engine kind of retention, that has nothing to do with the data retention directive. And we're having a discussion, the result of which will also be in this search engine report, which I expect to be adopted somewhere before Easter. Alvaro pointed at the need for a third pillar data protection. Yes, that's a very important subject. I hope the Portuguese will make progress, but I'm afraid that the result will not be so satisfactory. And that is something we will regret. And this is a more general point. A lot of energy is in the privacy versus security debate. But in that debate, many people overlook that it's not about privacy and security only, it's about beyond the security discussion. It's all the rest. It's e-health, e-commerce. It's the normal behavior of normal people. And in fact, the more we talk about public security, the more I would think that population is to feel about privacy in similar terms. But this will be more important, and there is much more. Finally, thanks for your enhanced powers for DPAs. If a number of member states would simply implement what is already in the directive, that is intervention powers, that would be welcome. reinforce their independence. In some cases that would be necessary. But yes, in my future, say, elements for a future vision, I would think that we need to be more flexible, but also ensure heavier sanctions if things go wrong. We really have to enhance the responsibility of the actors on the internet in the privacy online context.